on in, guys. Come on in. Welcome, 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 welcome. Are y'all ready for another day of debauchery? It's going down in the YSL courtroom, and we are here for it. Yesterday was absolutely action packed, to say the very least, and we are getting right back into it today. So, without further delay, we're just going to jump right on into the trial, not even wait. You guys know I like to start a little bit later and have some extra time just so we can jump on into the trial and have some TiVo time. That being said, let's go ahead and get started. Pull up the feed. Let me know what y'all are drinking this morning. Y'all know I got my Americano hot this morning. Hot, right? We are not doing cold coffees today. It is raining where I am. So let me know where you guys are tapping in from and what your morning drink is. We will go ahead and get started. It looks like Judge Whitaker is in full force. She's in rare form this morning. So I'm going to go ahead and screen share, bring up the feed, and we can get right into it. I'm going to bring us all the way back to the beginning. Let's go.
But I believe that Ford is being proffered to support the position that alleged violations of the rules of professional responsibility are sufficient to support disqualification. For a couple of reasons, Your Honor, I just ask that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, two general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification. And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees.
That might be what we're seeing,
if true,
Brian.
that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest, where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick. The court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bunkers present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. That interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify. And if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shark's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shark's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shark's amended motion for a fair trial. So
That filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay. All right. And so I assume you have made the determination not to present any further evidence on that one issue about whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right. Yeah.
One more thing. We did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He sent it generally. It may
Oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would move or operate, we would to therefore require, if we're going to put up evidence, we're going to put it up. I don't know how to.
Shout out to King Slime in a suit today.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so.
And so if that's the case, we would ask to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, where proffers are okay, I'm okay with that.
Okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So that
Okay.
got through the 5 jail calls the state since introduced Mr. Copeland. And I also confirmed and spoke with Mr. Sharp, Mr. Steele. We were in agreement that we handled those jail calls related to Mr. Copeland on Friday.
Okay, I'm sorry. I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection.
In relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay, so, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on. And there was, other parts where, like, for example, one of them was the text Gator. You asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hilton was at the.
I never hear this man
I will
speak.
work on-
I never hear him
We'll get
talk.
those notes from Deputy Hilton.
Okay.
That actually is what all we discussed on.
Okay. All right, so then moving on to our next issue. Yes.
Good morning. Good morning to everyone. I agree
Shout out
with
to
Mr.
Steele.
Atkins. We spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have. in my notes, and I
That's
think-
what I'm talking about.
and I think-
So,
Yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Ms. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so, right when we left court yesterday, we and Mr. Shard spoke about the jail calls, and remember I asked, we covered everything with it, and we were in agreement? Yes. That's right.
And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay, so, but yes, there was still something outstanding y'all needed to do. So
Yes,
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele, Mr. Sharp. I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was important.
Okay.
I will speak with them expeditiously.
Okay.
to rectify that.
All right, thank you.
Okay. We're supposed to be figuring out Woody all day
All right,
today,
so
guys.
then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and the further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Yeah, what are we doing about Woody?
Your Honor, I can speak on behalf of Mr. Williams, Mr. Stillwell, and Mr. Kendricks. The stance is that everything post the recusal needs to be redone.
Okay.
Just because we feel that that's the applicable law and that's where we're at.
All right, what about, Mr. Matthews? What's,
Good morning, court. On behalf of-
Speaking of which, Maria.
okay. And then, Ms. DeWilliams, what's y'all's position? Speak into your microphone, please.
Shout out to Angela.
Same position as Mr. Hughes, Your Honor.
Okay. All right. So I've got another question for the defense, and that is, I think that everyone has joined to the assertion in both of the pending motions that I mentioned before that the William, Stillwell, Kendricks, Huey, Ryan. Oh, yes, I don't know. Sorry. Nichols.
Clearly the forgotten person in this case who should be severed and who continues to object to the admission of any of Mr. Copeland's testimony against Mr. Nichols. So our first position is we object to the admission of Mr. Copeland's testimony against Mr. Nichols. Second position, that if it's admitted, it comes in with a 105 instruction.
All right, I've asked you a couple of times to give me a proposed one.
Yeah, we have it. We
Okay.
have it. We're going to give it to you prior to the time the jury comes in, if it comes in, because that's still outstanding. And
Okay.
And number three, we would, as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the
Oh, Kim.
proposed limiting, I mean, jury's coming back before too much
Kim.
longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence.
All right, guys, we are on a little bit of a time delay, but I am keeping track on Twitter to give you the current updates. I do that purposely, so if there are any breaks in the courtroom, we can quickly speed up and bring you guys back up to speed. It really isn't that much time. It's usually between 5 to 10 minutes. Today is a huge day. Why? Because we need to determine what we're going to do with Lil Woody. Right now, it's the defense's position that they, and I don't know if you guys just picked up on that, they do not want anything that took place after the recusal to be included. I'm hearing that Lil Woody may be in the courtroom and we might be able to see him today. So let's go back in and catch up.
This is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great.
Y'all hit my like button, please.
No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, of the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is included and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to testify. He could choose what he wants to do, and then we would strike everything. he said.
Okay, well then let's go ahead and find that out. Can you get him?
Oh my God, Woody's coming in.
Because here's the thing. But
We're going to see Woody, guys. Get these likes up.
Everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue
It's going down.
from
Let me change this
whether
thumbnail.
his testimony post June 10th ex parte meeting was coerced.
Y'all type Woody in the
And
chat.
if it was coerced, then what then? Do we then how do we still say, oh yeah, but I want, some of that testimony? That's still good.
I thought you, and listen, I have so many, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. Then you give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck. Give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because and thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced? We have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it, or find out. Does he at this point kind of redo are you intending to take a stand and die, or are you going to be held in contempt?
that's what I thought.
Okay. All right. Just so sounds like then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, that's that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's on Mr. Stillwell's behalf revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway. But
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
All right, what's happening here, guys? So Love and the judge are going back and forth. The judge just said she wants to bring Lil Woody in to ask him some questions. Adrian Love is trying to prevent that from happening because a big part of this is, was he coerced into testifying? That's what the defense's position is. ADA Love is saying, no, he was not. And shout out to you guys in the Fashion Files. Yesterday, we had a big debate about pants, and now I can't unsee it. Someone said Patrick Starr. I cannot unsee it now. There's even pink matching shoes. So let's see how this ends up. I know he was in the courthouse yesterday. It is likely he's in the courthouse today on standby if they need him. So let's just, I did say that we might see him today because she just said that. However, let's pay attention to the discussion to see if ultimately he is going to come in, because the judge is very, very concerned about his credibility at this point.
So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate, that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, I mean, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed worried out about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of the this is or isn't perjury things are a little, I don't think quite exactly accurate either.
Okay.
So I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
Okay, so when, that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the, motion to compel that needed filed. Because it got to a point where he's trying to not testify. We would of course ask the court to compel him to testify. And the things that have happened. And he was, as I said, he was represented by counsel, as the court already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week.
Like today.
And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But I mean, the more prudent course would really be to just bring him in here like tomorrow.
Yes.
And if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know
Does he have
gotten rid of Mr. Melnick and Ms. Bumpus at this point.
Yes, that's correct. Mr. Melnick withdrew representation. His father was fired, so no one has said anything to us.
Okay.
So does he have a lawyer?
So we are unaware of whether he has any
Okay.
representation.
Wow.
So point out just that since he's still under that immunity grant from the state, my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him.
Mm.
And he was not exactly accurately advised as to that, I don't think, at least potentially.
Ooh.
Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are.
Are we bringing him in today?
Would that work for everybody? Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes. Okay.
Yes. Yes, Your Honor. Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not had any communication with that person while he's on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that the court allow us, because like we have had to transport the witness, I request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean,
Let's get him today.
no, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow for examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential.
This is actually huge, guys. Let me just pause for a second. What the judge is saying, she actually did say, Miss Love, y'all fucked up. Here's the thing. She says, because there's two things. One, Lil Woody had immunity at the time that he testified. But the other big concern is, does Lil Woody have a lawyer as of right now? Miss Love, this is their witness. She testified, or not testified, she just said, okay, he released Kayla Bumpus, so Kayla's not his attorney anymore. He released Melnick, so Melnick's not his attorney anymore. Right now, we don't know who Lil Woody's attorney is. And that's what the judge is saying. She said, I don't think that you guys accurately advised him to what his rights are. So we're going to start fresh. We're going to start clean. We're going to tell him, yes, you have immunity, but he needs to really clearly understand and be accurately advised on the next steps. She did, the judge is trying to move this along. She's like, can you get him in here today? So it's a possibility, but she's also trying to get him in there at least tomorrow. Whose responsibility is it? Miss Love's and the prosecution's responsibility to get him in there. From what I heard yesterday, he was outside of the courtroom, so it's likely he's close by. It would be nice to get him today, but she is saying, I'm going to give you a deadline of tomorrow. Can you do that? Right? But at the same time, that was a huge little thing that we just saw where the judge is saying he was not accurately advised. He was not. So that's a little bit of a loss for the prosecution today. So let's keep going.
Potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it because there is potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I think he's probably entitled to counsel if he wants to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. Yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone just bring him in. We
Okay.
know where he is, so I can actually ask.
All right. If we can find him and even, I don't care if he shows up by Zoom for me to ask those questions.
Yeah.
that's fine with
Even
me.
today. Let's get him today. She's going to try. She got her phone out.
All right, so if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to, recusal motion?
And while they're muted, if y'all could do me a huge favor, I really don't ask for much. I streamed twice yesterday, and actually twice on my side, and we did a late night stream last night with Lead. He's not feeling well this morning. If that changes, we might switch over to his side later. But if y'all could do me a huge favor and hit the like button for me, please. Yesterday, he actually was the one that got my likes up by encouraging me to lock you guys out of the chat. You know I don't do that. So if you could do that for me, that'd be fantastic. Again, we're running a few minutes behind because if there is a break, I like to skip ahead and bring us current. With that being said, hit the like button if you haven't already.
Y'all can think about that for a few minutes. Ms. Freshfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachery? I think you said you had at least a good portion of that ready.
Yes, so counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but we have objections to those, and so that is
Okay.
right here.
All right, that sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and see if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachery evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if the defense counsel objects, I can send what Mr. Sharp sent us so the court knows what we're
walking through.
Yes, Your Honor.
That'd be great.
It's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I do. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Yeah, and maybe pick up your mic. And y'all, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet. So it's now on and I am holding it. Mr. Atkins, Ms. Love, Mr. Zachery's statement, his statement that I did not review yet, or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the 18 feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I can't remember how loud I am. It is possible, and there were, I think yesterday when I spoke, I was expecting one more from you. There are two, the 2015, the August 2015 one, and then I think it's the March 2017 one, and we have your redaction request for the I think the August 2017 one. So do you mean for both of those, or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for any discussion with the federal agents.
So this, you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely the proposed redactions, right? So we'll just start on that one and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on another one, then that's fine.
Thank you.
Little gap in time there. Okay, looks like they have a little bit of a break, but guess what? We have TiVo time. So we're gonna skip ahead.
I mean, I guess it's statements over at Ms. Persfield or,
Yes, Your Honor, and I was gonna also apply, we have an extra physical copy of the transcript, if that
Right.
works for the board.
sure.
Thank you guys for getting my likes up. You're almost there. Almost at half.
Okay. Waiting on that to come through and then we'll get started.
It would be amazing if we can get him in today. Let's see if I can skip ahead a little bit. That's why it's good to be behind a little bit. It looks like the prosecution's looking for something and it's taking them some time to look for it. You can see them talking.
Because I don't have the, you want to hand up the hard copy of the transcript? Because I don't have the electronic one quite yet. I'm sure it'll come through at some point, but we can get started with the hard copy. Wow, that's a lot.
And they come up later.
I'll put the red to the side right now then.
Perfect, Your Honor.
Thank you.
More talking at the podium. Court reporters talking to the judge.
Ready with the first one? That's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a time stamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the part, I could follow. So if there's a
Okay.
discrepancy, I may ask Mr. Short specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proffer session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I see 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
It should be when it ends. So it would be like 10, I'm pulling up my document.
okay. It is, I'm sorry. Go ahead with what?
So that first one would be. That first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not all of everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at Crucial,
No, he's saying I wasn't crucial.
when he's saying I was not at Crucial.
Right.
And he can't speak about being at Crucial.
Mhm.
I don't have any objection to him speaking about or trying to speak about being at Crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them, I haven't synced them up with my transcript in my
Okay.
recording. So, because I've read the transcript and listened to it so many times,
Okay.
I'm going through it with that knowledge.
Okay.
I haven't synced it up. So I don't have an objection to up through line 10. I
Okay.
don't have any objection to it. Page 11, line 10.
All right, so that's out by agreement. All right, so that one's out by agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Is there something else anybody needs to take up before we take our morning break and let Ms. Love do that? All right. Anybody else? Nobody? Okay. All right. We're just gonna take our little morning break early. So we'll be back at 10:30.
Y'all see why I like to be behind, okay? So they are taking a morning break at 10:30. Let's do a brief recap of what we've seen this morning. We'll read some super chats, and of course, I have some court documents as backup that we can review. And thank you guys for letting me know when there's trolls in, because when they're in, pew, you can go. You can go. I have no shame in kicking people out like pew, like get the little flies out of here. Anywho, if you guys are just joining us, action-packed day yesterday. Here's a recap. Yesterday in court, we saw a few things. We started the day with Melnick taking the stand, right? Clearing a few things up, clearing up his name, and for the record, letting it be known what his involvement with this whole thing with the state was. We went through all 5 emails and we saw how he was really trying to advocate to have Lil Woody not plead the 5th and to not testify. Now, here's the thing. Miss Love got caught. She got caught up in that. And I think the judge realized it as well. They got caught because typically what you're supposed to do, right, is you're supposed to properly advise your witness what their rights are. What we're seeing, and I think the judge had some time to sleep on it because she talked about it this morning, they did not properly advise Lil Woody on what his rights were. Right? He does have the right to an attorney, but they were talking to him without an attorney. You could even see some of that this morning because Lil Woody, as far as the prosecution is aware, same thing. You see how some habits don't change? They are not aware if he even has a lawyer up until this point. They should have been made aware because if this jury is coming back, you're still about to talk to an unrepresented person. That is why today the judge really wants to make sure that little Woody is represented. So he has a lawyer that can properly talk about what his rights are and what the opportunities are for him and what the risks are for testifying. You know, Melnick did say like, hey, you know, like you're risking his life by having him testify, things of the like. I mean, Woody don't care. He is out there. He is making songs. He is all over the internet. He's all over Atlanta. You know, he has mentioned in people, if you walk upon me for your safety of mine, don't do it. You know, all those sorts of things. And Atlanta is small. Whenever I'm in ATL, you know, I see so many of you guys come up to me and you're like, hey, are you AV? I'm like, yeah, I'll be at the car wash. They're like, hey, are you AV? I'll be at Lennox. They're like, hey, are you AV? Like all the time. So Atlanta is very small and it's very easy to get recognized in the area, right? So we know that we need to parse that out. Now, Judge Whitaker wants to ask Woody herself today. She wants him now because she's just like, I just want to ask him about the representation part. It shouldn't really take long, but I want to hear it for myself. She's like, even if we can get him on Zoom. So right now, ADA Love, and during this break, we are back in about 20 minutes. During this break, we're going to find out, hopefully, if we have Woody back. But the ultimate goal of the day is to make sure that, number one, we want to talk to him to make sure he's not going to do any shenanigans on the stand. Okay. Like that, we need to make sure that he is cooperative. He understands his rights. He understands what he's getting into. It's likely he could plead the fifth again. You know, all of this has been going on since May 31st when the prosecution's office hit him with a notice and they're like, hey, we're hauling you into court. So this poor, I mean, not to call him a poor guy, because obviously he's in these streets. He said, I did these crimes. He has admitted to shooting back at someone. And I think that resulted in a murder. So although Woody is entertaining, this is definitely someone who's had a tough life and has been involved in the streets for a really long time. If you guys recall, Lead had a one-on-one conversation with him. I was supposed to be there too, but I had to step out for a meeting. But, you know, he kind of focused on just what little Woody's life has been like. And most of the interviews that people have had with him have been on a focus of that. The upbringing, some of the opportunities he did and did not have, what it was like coming up in Mechanicsville, all those sorts of things. So that is the focus of today. You know, the judge is not playing with the DA's office. She's just like, I would like for him to be in today. Can you get him tomorrow? And I mean, if he was at the courthouse yesterday, people are saying, according to Who Cares Media, people are saying that he's at the courthouse today. So it is likely that we could see him today. But that's going to be interesting because I think he was combative for a reason after that transcript came out. And that's what you're looking at. Also, yesterday, we saw Kayla Bumpus take the stand just to kind of talk about her experience with the case. Doug Weinstein was trying to get a 10-second clip in as evidence. And once he was able to do that, it kind of opened the floodgates for the defense attorneys to ask Kayla some questions and clarify a few things. And then the prosecution's office to ask her a few questions. You know, she was a stand-in attorney for Woody just for a day. You know, in her primary area of practice right now, I believe, is personal injury. She has history as a former prosecutor herself and a defense attorney as well. But I know Kayla's covering this as well. You know, she's been sharing her experience with it. Chat here was a little bit hard yesterday. You know, I had a clip to share my thoughts on it, but again, we're just going to move on and focus on what's happening moving forward. Okay, so interesting stuff there. Lots of people covering this. Kat Knott Williams, sister to this channel, you know, months ago, I had her co-hosting on the Jonathan Major stuff, and she brought me up to speed on that case. Kat is amazing. So of course, definitely a sister to this channel. I know there's a few other people covering it as well. That being said, let me cover a few supers. And the other thing that I do have for you guys is the ex parte document from yesterday that they were going back and forth on. It's like page 40, where they were looking at the moment in time where the judge was trying to figure out, hey, is this transcript complete, full, and accurate? We need to determine that. At first, Kayla was saying that it wasn't accurate, but the 10-second clip that Doug Weinstein was trying to bring in, what that was is Woody saying that it wasn't accurate, right? So there's a big difference between Kayla saying it's not accurate and a big difference between Woody saying it's not accurate. So as you can see, that's also another question that you bet your ass Judge Whitaker is going to ask him today. She's going to ask him that. Like, Woody, compared to what we've seen, right? We're going to ask you because you're the declarant. You're the one that made the statement. Is this transcript full and accurate? There's so many questions for Woody. So if he comes today, is really going to be an action-packed day. Let me come to my supers and see how y'all are doing. Shout out to Lord Vashida with $5 says, I just woke up and I already got content. Thank you, AV. Anytime. And that's my plan too for later today. My editing team they're like itching. They're like, where's the footage? What do you have? Like, I'm like, all right, I got to think. I got to produce. I got to direct. But it's hard to do that when I'm streaming. So if it is a slower day, I might take the afternoon off and just work with them to get y'all supplemental content throughout the week. But yes, we are planning on pumping it up as much as possible. Because remember, Judge Whitaker says that she cannot work on Friday. So whatever happens today, the outcome of today is really going to dictate this week, right? If we get the Woody stuff done today, the jury could potentially be back tomorrow. She doesn't want that. She would rather them be back on a full week, like a Monday through Friday. So depending on how what today's outcome is, we could potentially have a jury back tomorrow and Thursday. If not, they will be back on Monday. So they're not in the courthouse today. Just want to make sure that is clear. Shout out to AC who became a member. Welcome, AC. You're going to love it here. Really, really great community. These guys had me crying, laughing yesterday with pants, like you can go back and look at that. Like that was like the funniest segment of yesterday's afternoon episode. It was amazing. So welcome, AC. Shout out to D 199 says Lil Woody got Fulton County in a bind. They do, but think about it. Woody testified first or second week of June. I think it was like June 7th or 8th or 9th, right? Because of his testimony, Glanville got recused. New judge got assigned. The jury has been out since June. So many different things have been a result of his testimony. In a way, he is the most important part of this case for the prosecution, but also the part of the case that is destroying it for the prosecution. Ain't that crazy, guys? Insane. Shout out to Ayla Lopez. She became a member. Welcome, sis. You're going to love it over here. Welcome to the community. Really appreciate you guys picking up these memberships. Shout out to Scott A with $1.99. He says, Woody, please don't pull a Kayla. Oh, yeah. Well, I think he is going to recall some things today. I think he's had some time. Like, you guys let me know in the chat. What do you think his demeanor is going to be like when he talks to this judge versus Judge Glanville? This is a new sheriff in town. This is a new referee. And you guys saw her performance. Just from what you can see from this judge's personality, what do y'all think? Let me know. Some people are saying Woody's going to plead the fifth right away. People are saying they're disappointed in Kayla. A lot of people are saying Fifth Amendment. You think he's going to plead the fifth right away? Chameleon says the same. Nick says, I don't recall. Candy thinks he's going to tell it all. The No PC show says Woody not about to say anything while saying a little something. He's not going to be labeled a rat. Well, that's the other thing. I think that there is also this protection of a reputation with him. Where he'll say just enough, but not enough, right? And I think that that's kind of what was happening. So, you guys know how we have scrambling and scraping, no Diddy, but this is like ducking and dodging for reputation, right? The reason why I've always been concerned about the social media presence, and I know he doesn't care, right? I've just been concerned about it because when I was down in Atlanta, when this is all happening, it was probably like middle of June. I remember Tay getting a shot. And it was like the day I was there that night and left the Sunday. And I remember that weekend and they were super close. So that's my thing. It was just like, okay, was that a result of, anybody's involvement with this big case? Atlanta's dangerous, man. It really is. Miss O thinks he's going to be more respectful. Jay says he don't want to talk. Lady D says, tell it, meaning the prosecutor coerced him into testifying. That's going to be big. Because he knows what they did to him. Like when we read that transcript, he was like, I want to go in a jumpsuit. I want the world to see what y'all did to me. That's why all eyes are on Woody with this thing. It's super, super interesting. I'm just going to check the feed, guys. It looks like they are not back, and I'm all up to date over there. So I'll keep checking from time to time to see where we are. But yes, so many of you guys are thinking that he's going to either plead the fifth or he's going to tell it all. Somebody said he's going to jail. He's going to jail. Yeah, and guys, a lot of people are asking where Lead is. He was scheduled to be here. He's just not feeling well this morning. You know, we're all humans, you know, so I'm holding it down for our brother, and he will be back with us. It could be today, it could be tomorrow, but, you know, we're all humans. Sometimes we have good days and bad days. But yeah, the 5th. Bobby asked, why are they on break right now? This is their regularly scheduled morning break. Judge Whitaker is really great on time. She will typically start at 8:45, and then around 10 o'clock, they'll take their morning break. Sometimes if there are administrative tasks or if she asks people to do something to bring back after the break. We saw that yesterday with Weinstein. They took a short break because they're like, he came back, was like, I want to show this TikTok. She's like, okay, well, what part of the TikTok? Because not all of the TikTok's going to be relevant. If it's at 10 seconds, I want you to narrow down those 10 seconds, put it in a clip, and let's watch that. Let me listen to it. All the defendants have to listen to it. The prosecution has to listen to it, and then we'll play it. So when they have these morning breaks, it's not only just, a potty break. The other thing that they also do is they'll do administrative tasks like this as well. So that's why they're on their morning break. Usually their lunch is between 12 to 1. She's very strict on that. Yesterday, with the exception, Kayla was on the stand, so they took their lunch break around like 1. And then we came back from like 2 to 4:35. So they're pretty structured with their time, and that's why they're on break right now. But they should be back. They said 10:30, so in about 9 minutes. Cable Guy says, how much trouble will the court reporter get into if the transcript is off? I mean, that's a good question. I mean, it's a very serious job. It's a very serious job. It depends on how far off it is. It also depends on who told her to stop recording. That was a big debate yesterday because there was a debate on whether the prosecutors told her to stop recording. She doesn't report to the prosecutors. She's Glanville's stenographer. She has to take a record of what's happening under the regime of Glanville. As you notice with Judge Whitaker, you guys see that woman in the lime green jacket with the curls. Her curls are popping, by the way. She is Judge Whitaker's court stenographer. And notice that Judge Whitaker sometimes, like if the attorneys are talking too fast, she'll say to them, hey, slow down so my stenographer can take this down correctly. So the answer to your question is, I love my law school professor. It depends. 2 sexy words. It depends on how far off it is, what's missing, and we go from there. That's why yesterday Judge Whitaker was trying to pinpoint what exactly is missing. Is it a bathroom break? What were the words said? Things of the like, right? And we saw that in the afternoon where the DA's office brought up 3 of their employees, and one of them, that was the deputy, he was he was the one that was in the room, and they had to pinpoint what was said, right, to determine if that is a significant portion missing from the transcript. So hopefully that answers the question. Coming back to some supers, I think I left off as JC. Thank you so much for the $2. Says, in Woody we trust, # mistrial. Yeah, we'll see if we get a mistrial. But I know that this judge really, really wants to talk to him. I think the world wants to hear from him. So we'll see. Those 2 pending motions are still out there. We still have a motion for a mistrial that she has not ruled upon. We still have Steele's motion, which I have up here as well. So we could take a look at that. And what, not Steele, Stillwell's. So Max Shard's motion that he filed on Friday. And what he's asking for is a fair trial. All of you guys deserve that. Any American deserves a fair and impartial trial, right? Justice is supposed to be blind. Shout out to my lady Justice behind me. It's supposed to be blind. You're supposed to give people a fair shot in this justice system. You really are. Does that always happen? Absolutely not. But it should be happening. It should be happening. Shout out to E. Capone with the $4.99. What it do? How you doing on the West Coast this morning? Let me know how you're doing over there. Shout out to Audrey with the $4.99. Says, get TLA to represent Woody. That would be fantastic. To see TLA represent Woody, like come out of retirement, walk up in the courtroom. And y'all don't know, like he's huge in person. He's like 6'3" and Woody's 5'6". So that would be a huge height discrepancy. But I think he would be really, really good. You guys know how skilled TLA is with his line of questioning. He put me onto this book called The Cross-Examination Science and Techniques. We call it the Cross-Examination Bible. And when I was finishing up law school, I picked that up and I was like, this is actually how you talk. And then one time we went to like a YouTube lawyers meetup, right? And like I saw him with the book, like, just reading it for leisure. I was like, wow, is this what you do for fun? Like he loves this stuff. He loves it, but he loves retirement more. So shout out to TLA. Shout out to JC with $2. Says not TLA Arturo. Well, yeah, that's another thing. One of TLA's mentors and longtime law partner. I've had an opportunity to talk to him over on that side. He's hosted some shows with us. He is amazing, really revered criminal defense attorney in the Atlanta area. And he does like work with like the cartels and stuff like that. Like great criminal defense attorney. Imagine Woody and Arturo. That would be an amazing combo. So we'll see what happens with that one. Shout out to Joel Santana with $4.99. Says Miss Love's pants are in the hamper and the one eye open when she heard Woody was in court today. Love what you do. Glad to be here from the start. Thank you so much, Noel. Really appreciate the super. And I see a few of you guys on the Cash App side. I'm gonna come there in a second. But yeah, listen, y'all took me out yesterday with the pants jokes. Because I know it's my fault. I noticed it. I was just like, why her pants look like that? Like, like if you have trousers, it's usually a line that's stitched or there's a button, but they were like busted wide open. I was just like, wow, and then y'all were like, they look like eyes. I don't know. I mean, ladies, we might have to raid that closet just to help a sister out. Like sometimes when you're in this legal game, you don't have time to get a tailor. I have one. Matter of fact, he texted me yesterday, like everything is custom for my body. Like I have a beautiful, like it's a royal blue suit, not like a lead blue, but it's like royal blue. I cannot wait until it's ready. And then I have him working on another one right now. I think it's going to be like a fire red, and then he's going to put this AV7 logo in the inside. So that's going to be amazing. I plan on wearing that one the day because when you pass the bar exam, at least here in Massachusetts, they have a swearing in ceremony. So like, sometimes if you want to focus on goals, you have to like make them kind of happen in your mind. So for me, like it's going to suck getting ready for this bar exam. But if I see that suit hanging up every day, I'm just going to focus on that day. That's the day that really matters to me, right? So fire red, I don't know, or maybe the royal blue. You guys let me know. But even with that, building this channel is like a little mini company. So, my legal career has really led me to do fun things like this. But at the same time, I know when it's time to practice, like I'm really going to take care of my clients. So that's going to be fun. Thank you so much, Noel. Long little winded story there, but hopefully we are back in 2 minutes. We're trying to kill time for you guys. Shout out to Ashley D, who says, AV, when is your birthday? October 5th. I'm a Libra baby. Like a little Indian summer, baby. Shout out to our Libras. What season is it right now? It's the Leo season, right? Shout out to all the Leos. Shout out to D with the $4.99. He says, AV, you're going to learn your bones as a public defender or a DA. I don't know. Watching this stuff I'm curious about criminal law right now. I have one girl I went to law school with. Oh my gosh, she drives a Maserati now. She's in a partnership with her boyfriend. I think husband now. Dude, they make so much money. It's insane how much you can make in criminal defense. Like they have I don't even want to talk about it because as soon as she used to pull up to school in a Maserati, I'm like, God damn, what do y'all do? But a lot of criminal defense attorneys rocked with her because she used to have a full sleeve of tattoos and go to court like that. Like some people like criminal defense, but it really is about deep knowledge and understanding of the law, but you got to like what you do. My only uncomfortability with it is it depends on the crime, right? Because here's the thing. If I'm your lawyer and you tell me a secret, I got to take it to the grave with me. So if you do some really egregious shit, I have to, have that poker face and not say anything about it, but also defend you to the best of your ability, of my ability, and also not judge you for it. Sometimes, depending on the crime, I don't know if I can do that. So I don't know, D. It's a good question. It's a really good question. Shout out to Anthony Peterson, $5 says, "Oi, I'm trying my earbuds while at work. Only I need eyes and arms for the job. Thanks, AV." Good. Listen, yesterday, some of y'all got so mad at me. You're like, "You're so loud." I literally have to push the mic back now. The mic is over here. Usually I have the mic right here. The mic is like back there because I'm not trying to blow anybody's ears out or get any complaints. And a lot of it is sound balance between the court feed and the court feed that we have and the audio feed that we have too. It's a hard balance, but I have got my mic on the lowest setting, guys, and we pay attention to all of that stuff. Anthony is back with another 5, says, Woody says, "I never told the truth till now." He's not going to say much to help anyone. Little bit of movement in the courtroom, so we might be coming back in a minute or so. In the meantime, shout out to Orlando with the 10, says, "Woody is going to be comfortable with this judge. Woody has one emotion with this judge." Yes, thank you for saying that, Orlando. Woody has been in front of this judge on his own criminal cases. So that's an excellent, oh my God, shout out to Orlando. That's a good point. Because he's presided over, this judge has presided over his case, and I believe Woody won a few things. And the case is done, but that's what Melnick said yesterday. So Orlando, look at you, super observant. That's actually a really, really good prediction. So we'll see. And I think that's also why she wants to talk to him, because she's like, he's not going to act that way with me, or maybe it's not so bad. She's had experience with him before, and Love is trying to prevent that from happening. Interesting. Super, super interesting. Shout out to Mega with $4.99. Mega says, "Woody's making money now. I seriously doubt he's willing to do jail time as he was when he was first called to testify." Also an excellent point. He don't want to be in there. Have y'all heard about the Fulton County Jail? The fact that human beings have died in that prison. Why? An infestation of bed bugs. Ugh, ugh, like bed bugs are gross, right? And if you ever see one, I don't know if you've ever had this problem. I had some friends that have had that problem, and it's like you can't, apparently they're really hard to get rid of, so and if there is, let's say you live in an apartment building or something and your building is infected. So imagine being in a jail where you have nowhere to go and you have no choice but to just deal with it. And you're sitting there getting bit up and somebody died of that. Like, how do you die from all of those bites? How? The shenanigans. Ugh. So, Woody don't want to be in there. So I totally agree, Megan. Thank you so much for the super. Shout out to Drew Beats with $4.99, says, "Hey, I'm just waiting for cross-examination of Woody." That's the other thing. Imagine Steele on Woody. Imagine Shard on Woody. Imagine Weinstein on Woody. Imagine the gangster Bruce Harvey on Woody. Imagine that.
As far back as I can remember, I always wanted to be a gangster.
That's going to be insane. I cannot wait for the cross-examination. So that's a really good point, Drew. Shout out to Shay with the $5. She says, "Woody testimony is not reliable. Why is he still going on the stand?" Well, I think it's because this judge has to bring us back, and that's where they left off. They left off with him on the stand. So they have to determine whether or not we're going to start over with him. That was the big question that we just watched for the last hour is, are we going to start over with this guy, or are we going to proceed with where we're going, right? So that's the big question, Shay, but the reason why is because that's where they left off. So we're resuming, and we cannot bring this jury back in until we have a resolution to what we're doing with him. That's why this entire day is dedicated to deciding what we're going to do with Woody's testimony. So thank you so much for the question. And it looks like we are back, guys. Thank you so much for the supers.
Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's total redactions, and there are some that I agree to.
Okay.
Not a whole lot, but
Yeah, the proposed reduction, yes.
Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to.
Yes, I don't have any problem with that. That's the discussion of the search of defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All
As well as number 19, which is on page 73 of the transcript.
right. All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Could you just give me the number of the section you had to look at?
17.
So 17 and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachery, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right. So we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep out. All the way through 9422. Mm-hmm. 9211 through 9422.
He is Danny.
What I've gotten to agree to, if the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or
All right.
I can.
Let's do that right now. And
All
then
right.
over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those. Okay?
Did the state agree to 27 or no?
It's,
No, we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right. So I guess that means 2 through 16, we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yes, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up the house.
The audio is as
So-
high as it can be, guys. This is their feed, not mine.
Page 13, line 16 starts at Dennis talking with the witness about the house getting shot up, and this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Demikion Garlington about people that call him that night, starting on page 12, line 14. And Quindarius Zachery is talking about his girlfriend telling him what's going on.
Right.
No, Vita, I'm not sure, but I can ask my contact in the courtroom.
Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shot up. It's the why the house got shut up, which the objection's speculation.
So my argument, assuming I established the proper foundation,
Thanks, Smoke Jaguar.
is that
We'll look into
with
it.
Quindarius Zachery saying that Trevante was helping D-Fight. He's talking about Demikion Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the,
Okay.
granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
That'll work. Okay, so the next one being page 25. So 25, page 25, line 9 through 2512 is a direct statement from the witness about an
I heard
incident
Gigi.
that's listed as an overt act on the indictment.
Okay,
And what they were doing, it's an admission.
all right.
It's an admission against his.
All right, so what's our objection there, Mr. Short?
My objection is drug use, and the character that's associated with that, and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, um, or state of mind. The reality is, within this context, is a story about that Mr. Zachery gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachery, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him.
Who
not
was
getting out of
high?
the car. We'd argue that it's
Somebody was
intrinsic.
high?
It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On they really didn't care part, are you maintaining that part should come in?
Not Xanax.
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that, wait, you.
right. What's the motive? The motive's just they were hot.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number.
And guys, while we're waiting on an update on Woody, what they're doing right now is they are preparing for the next witness that the state is going to call after Woody. His name is Quindarius Zachery, right? So right now we're going through all of the statements for Quindarius, because let's say that the plan fails and we don't even have Woody on the stand, or, him being on the stand is quick. What I like about Judge Whitaker is she's preparing for the state's next witness, because as we saw with Judge Glanville, the case was a dumpster fire for a reason. There was a lot of wasted time. She's skipping ahead because where we are is trying to get Woody into the courtroom today to answer a few questions, but we're not going to halt everything and stop everything because we're waiting on that. We're going to move on to the state's next witness, and we're going to see what that person is going to say on the stand. We're going to hash everything out. We're going to go back and forth between the prosecutor side and the defense side to see if this witness has any issues before the jury comes back. So as you guys can see, this judge is committed to not wasting any more time.
The next one is further down. Mr. Zachery is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachery responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm
17
sorry,
through
25.
17 through 20.
Yes, I'm sorry. So 17 through 20,
Right.
he's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachery was charged, and in his proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachery is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachery can speak to his own intention, unless he says Mr. Stillwell was there and this is what Mr. Stillwell said or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachery, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachery, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked, what was y'all's intention? And that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All
that they
right,
are
so
having
where's that?
So up. On line 4, he says, because he said we're not going to shoot, how to be that to them. So on line 2, investigator Dennis asks, why does Moontoon, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachery said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachery is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's
Line 9.
talking about what Moontoon said. Moontoon's not even here. My client is not Moontoon. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachery. But what Ms. Love talked about is Moontoon telling Mr. Zachery.
Sorry,
to
you
not
took
get
me
out
out
the car,
yesterday.
saying we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachery, that my client indicated what the intent was, what the plan was, That's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out of court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It
Okay.
is. Okay, so assuming you need to use it as a prior inconsistent statement. or-
Yes, and in response to Mr. Sharp, Mr. Zachery is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachery to make that, to draw that conclusion.
But Mr.
So
Zachery,
I don't understand why Mr. Zachery, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachery's saying is he gets a call from his girlfriend Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachery doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachery last. And Zachery does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachery gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that.
Oh, Max lost that. Looks like that statement is coming in. So again, guys, Quindarius Zachery is the next witness,
All right.
and we're going through his statement.
28, line 17.
The
No.
font is a little small. I'm just having,
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this instance. The
So
shooting of
this
the houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachery is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been,
Did somebody get shot at this house?
yes.
And that evidence will come in through this what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot? Okay, so then that is all right.
Okay, we're learning more about the other witnesses, guys. Beyond Woody.
All right, number 6. And I guess let's make this 3-page proffer of proposed edits a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
Okay. So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachery is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachery doesn't correct him or doesn't say anything about it, I would argue it
How
just
would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it
don't,
out. Strike it. Granted.
Ah,
you're, okay.
I like Whitaker.
Out.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So
All right.
the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachery is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Munktunk, Demikian is in the back with you and Shannon is in front, and then and then Mr. Zachery says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindarius Zachery about activities that YSL and Rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kale, and Mr. Zachery says no. it's, he corrects him, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachery later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count one in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying we thought y'all did it, but
No, line 17, where he says they tried to say that we did it on on page 33.
oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish,
The existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
all right, Mr.
So,
Sharp?
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe, I don't know.
with
I
this-
know, they're all annoying, they get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachery also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay.
This is a gentleman who, you know, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't.
Real quick, guys, this is actually important. I don't know if you're picking up on it. Remember when we were during break, during the break I had mentioned and we were killing time. I was telling you how in June there was a gentleman named Tay that passed away that was super, super close to Lil Woody. Lil Woody was posting pictures of him and Tay like that whole weekend leading up to the funeral and things of the like. Now, what did Max just object to? Apparently, his name is Trevante Turner, Tay, right? This is the same gentleman that died like pretty much 6-7 weeks ago. So it is alleged, and here's what he's talking about. Quindarius Zachery, the witness that we're talking about right now, when he was talking to detectives, he said that Shannon, Garlington, Sledge, and this Tay were all in the caravan that performed this shooting. It is interesting because Max is telling us that he doesn't think that Tay was affiliated with YSL. So let's see how this conversation shakes out. But I just wanted to connect the dots for you. That's the same Tay that we're talking about right now. Okay. Let's see what Max finishes us off with.
I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachery saying Trevante Turner was part of this mission that he's claiming existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purpose of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here. This incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk. You know, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 15-026-2801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
but
an
that's,
associate of YSL and a member of YSL aren't the same thing.
they aren't, but I'm not asserting
She's got
one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachery, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men, he's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person,
Go ahead.
she does.
so
All right, let me.
so if gang is the gang that
So
they're
is that the they here? This is the
associates
part of the gang
yes.
that there's the alleged beef back and forth in the series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group.
I think there's an
about
update on
something
Woody,
that
guys. Did
The
y'all see that posted?
declarant, in this case, Mr. Zachery, is actually saying they were wrong about. How's that?
We might have an update on Woody, guys, because remember that man just came into the prosecutor's office or prosecution table and just spoke to the gentleman in the gray. He wrote a message on a Post-it because that's how we communicate in court to alert Miss Love of something. So let's see what that was.
Admissible to anything, and if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant and it confuses the issues.
And if the court goes on further down, and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachery says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right.
He's literally saying, no, that didn't happen.
Right. but she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachery is saying, yeah, there's this we here that is YSL, and that is irrelevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachery, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, and whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other
says
words,
something
don't try to
different. You're
get
like,
him, don't
"Ah."
try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right. Moving on.
Hello, Chris Kringle. Long time. I think I know what I want for Christmas. We got to talk.
36.
Number 8 being page 36, lines 1 through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue.
The judge is laughing at
consider
her.
that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And Your Honor,
And
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah. All right.
Captain T.
Well, I mean, he's got it all as number 8. So,
Okay.
all right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then Investigator Underwood and Dennis and Zachery are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot
All
up.
right, is
Has
that
nothing to do-
relevant?
So, Judge, in
Welcome,
context
Cynthia.
37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
It's-
Correct.
Okay.
Ladies, y'all know when we start leaning on them heels, we know it when we see it.
For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right, so that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because.
Let's
this
not wait
happened,
till the last minute to do it. Okay.
It would only be it would only be by virtue of something happening on the stand.
Okay, I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachery giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay,
K-
so
and
that's
boy called
lines
KL.
3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called KL. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay, well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39.
Sorry,
line
guys.
11.
We have a special guest. I might have to bring her up.
8
Okay.
through 39, 11
Really to 39. It's
through 39, line 1.
the end of 39.
Yes, buy a dog.
It's two different incidents. It's a
This is our
discussion
stream
about
dog, family dog.
Tay,
She's entered the chat.
people saying on the street. Again,
This is
I don't-
Luna.
I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that the
Right.
jurors would have. And they're talking about people on the street saying that Tay shot up Rich
She
Homie
broke into this
Kwan's
office. I don't know how she did.
dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right, she may
Oh.
not, she may agree.
I have no objection to 8 through with the clarification that he made, because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay,
of
so,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 through
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all?
19.
One, okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then they
yes.
start talking about Tay shot Kel.
And
I don't. Again, I don't represent Tay. Tay's not associated. So, but it's just I just
Alright,
think it
he
would be
isn't.
confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right, who is dead and not on trial here, right?
That's true, unfortunately.
Okay, so is it relevant?
In it,
I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
Yes, it goes over into page 40. There's a video that we're going to have about with Quindarius Zachery, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is If Gang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mm-hmm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
It's not relevant.
I don't know I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's gonna be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachery.
We don't.
Saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right. Hang on. Ms.
So-
Love.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin shooting up Antrevia's
Is
house.
Young Thug sleeping?
That part is correct, because Antrevia Smith relayed.
Young
to
Thug
the
is
police
sleeping
when she
in
gave them
court.
that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachery is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that
He's
at
up now.
this time, we're going to talk to him. We've noticed the defense about our intent to
Yeah,
talk
he
about
tired.
when Trevia Smith's house got shot up.
Mhm.
It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to
Look at
introduce
Thug's
evidence
suit.
of.
If they bring up shooting of Trevia's house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachery lying about it. What we're dealing with here is not Mr. Zachery lying. Mr. Zachery wasn't at Trevia Smith's house. Mr. Zachery was not shooting at Trevia Smith's house or being shot at Miss Smith's house, Trevia Smith's house. Mr. Zachery is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shellkel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachery has no first knowledge of.
Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachery was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right, let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay.
Yes, save us some time. Thank you, Judge.
'Cause I mean,
Whitaker.
I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
Those were all the other defendants that he was zooming in on.
And that's all the way through 42.
All right. So.
Atana Clar, that is correct.
So the next one is number 10 is 42. Line 17 through 44, line 6. What is it? So when the objection is lack of personal knowledge, I am laboring under the assumption
I
that
love this channel.
Mr. Sharp's belief is that Mr. Zachery lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shellkel shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have gotten in, we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachery is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our objection.
Okay.
All right. All right.
So I'm gonna take that out.
All right. Number 11, 45.
That should,
15.
number 11 should be 46,
Okay.
line 15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachery just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have.
All right,
any
that- she
objections to that
agrees.
part coming out. Mm-mm.
Okay.
What's her name?
So
That's
that's
45:15 through 46:16. I agree.
As we don't have an update yet, they're trying to get him today, but we don't know if he's in the courtroom yet. The judge wants to talk to him today, though. So we're going to keep an eye out on it. And I'm up to date. I'm only 50
Okay,
seconds behind.
let me interrupt y'all a minute. I have word that Mr. Copeland.
Oh,
is
he
here
is!
and available.
Woo! Let's go! Let's go! Let's go!
And, have him in, see if he has an attorney, see if he wants an attorney.
Guys, Woody's coming.
Yet have anything put together that I'm going to advise him of, but
I'm good
we
with that.
we
part.
could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's-
Okay.
Here he comes, guys. Shout out to Woody. Could y'all drop Woody in the chat? Sorry, Kia. I'm just excited. There he is, guys. Here he is. There he is. There's the man of the hour. We
Good
haven't
morning,
seen
Mr.
him in a
Copeland.
while.
Judge Whitaker, I think you've been before me before in unrelated matters,
Huh?
but I'm the judge taking over this case now. So go ahead and have a seat. What I
Hold
want
on.
to ask.
Hold
taking
on.
over,
Hold
you've
on,
been
guys.
before me before.
We haven't seen Woody in a while, okay? What is the first thing he says? What is the first thing he says?
Good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I know one to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether.
said I was talking to Melanie, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay, does anybody know whether that actually occurred?
Oh my God.
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was.
There
but-
was nothing about Mr. Melnick to my knowledge.
Okay, maybe
There was, Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melanie off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify,
Huh?
so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But
Oh my
I'd rather have
God.
Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
To the end of this trial,
Yes.
not the other people.
Not as far as I believe, but the state, what, did you want to do some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where the whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you.
Wow, guys, we're gonna hear from Woody today. He said, huh?
So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, I will just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena,
Oh my God.
then you show me what authority lets you believe that. Okay. All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday. She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said.
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know,
Correction.
what that means. I'm just going to reach out to Mr. Melnick.
That's
and
right.
At least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
Yes, Your Honor.
All right. Okay, so let's get a few minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good. All right, so we were on number 12.
And while they do that, guys, I mean, this is ridiculous. They're basically, and I really want the judge to hone in on what the state is trying to do here, because they are saying if Lil Woody does not testify, he just asked if he is going to have to stay in jail until the conclusion of this trial. I mean, if y'all think that's justice, I don't know. So we'll see. Like, it's almost, you're still forcing him to testify. So yes, please get Melnick in there. And I did start a poll for y'all.
Number 12 being page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay. So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J,
Bloody J,
who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachery's rendition of what happened, that we would argue it's Mr. Zachery's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Sharp's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachery's
Being
ability
a
to
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
So
let me ask Mr. Sharp, is the basis for you saying you don't think he was there that no on line 23 when is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no,
Okay.
it's not based on that.
Okay. You have no
actually
reason to
do not
believe.
know.
Okay.
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
Okay. We
And
know
I-
whether
and
he
this
was
is-
there.
page 48, line 5. Start at line.
So we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And then
withdraw.
somewhere else, he says, would he, okay, all right, well then you'll withdraw that objection?
If he's there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachery repeats the question. Ultimately, Zachery says, shoot, they say Woody and them, I don't know for a fact. So I would agree and argue that you don't know.
Okay,
So it's
He's
not,
telling them,
okay. So 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachery, later, he tells earlier in 2015, he relays to law enforcement about statements made to him by two people in the courtroom now. And two people admitting having killed Diamond Thomas.
Okay.
This statement right here is after 2 years later. So, when he says, they say Woody in them, I don't know for a fact.
Mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay.
so, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually, in this statement, Mr. Zachery claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
Okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay.
So, if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
Mhm.
that my client said something to Mr. Zachery, or that Mr. Kendrick said something to Mr. Zachery, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right.
but
I
then
don't know.
later on he says, my client directly said this.
All right.
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. Right, before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see I see what you mean. If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him at night. And if he's holding that information, then him answering, they saying Woody and them, I don't know.
All right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think
right? So,
who the
Turning up.
streets are saying.
okay, well then, for Mr. Zachery to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be this 18 through 22 would not be inconsistent to a statement by Zachery that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they
All right, well, I would reject that argument. So that's out.
Oh, wow.
All right, so
Not good,
next-
Max. They probably have time for one more before it's lunchtime.
Is, what, 20, page 54, line 23 through 5511, is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22.
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that,
All of that, we would object to it being redacted out. All of this is Mr. Copeland talking about.
okay, so, all right. The,
Not Mr. Copeland, Mr. Zachery, not ours. So I don't know how.
okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact. I see what you, no, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact. I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
Can y'all see how? Do y'all see how important the word "they" is in the law? Like seriously, we were talking about this last night on Lead Stream. The word "they" and pronouns and using these plural words to describe people is very, very important, right? But you see how we get tripped up with this.
Because it's one of those.
It's all over the place.
No, it's, as it relates to the way that Dennis is talking to Zachery,
Yeah.
he means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video
Yeah.
of this part because maybe the inflection will let me know whether he means. Let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's an MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds.
I
Okay.
believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move,
The "they" must be named.
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me the video. So yeah, let's, if 5722 through 23 is a separate kind of issue, we can move on to that one.
See my people on the West Coast joining. Morning. Are you on the West Coast, Mike? Where you at?
All right.
I have 3 digits. I know it's meant to be, probably, is it just 5722 to 5723? It has 223.
I think so. Your objection, Mr. Shart, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to.
They did these crimes.
All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
CM, no, they are not. They names must be named. They need to declare a mistrial. You know how they are.
So, Your Honor, this is.
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
Shout out to our stream sponsor from yesterday, Miss Whitney. She's entered the chat. We'll see, Whitney. We just polled the audience. Let's see what everybody thinks.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachery why he's guilty by association.
Yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be. But I can understand that. You wanna agree to that, Ms. Love?
Judge, if the court will give me, my counsel is sitting here whispering in my ear, if the court will give me 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm here in the court.
We'll see.
They not like us. They don't recall. They should make a shirt and put they on it. Y'all are cutting up today. They ain't like us.
I'll give you about 10 more seconds to make your decision. Then I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right.
Damn, now y'all got that song
So
stuck
that
in my
is
head.
Out by agreement.
And
You
Your
know,
Honor,
like us.
Yes.
They got me discombobulated. That was a good one. Yeah, Mike, you missed Woody. We might see him if we can find Melnick. They feet hurt.
number 15 and number 16 starts at 66. Line 12 through 66, line 18 is what I understand.
Wow. You guys look, or 71% of you think that Melnick is going to show up tonight or today.
Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12, starts out talking about the gun that Mr. Zachery got caught with on May the 7th, and then Investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachery saying that's Motu's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachery is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count one and the gang count in this case.
That's not my issue.
Count one.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontook or that's Moontook's gun. That's fine. What I have an issue with is saying with Investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's
Okay.
mom's house. And there's a couple reasons. A, it's not been put in evidence
Okay,
yet.
well, hang on, maybe we can address your objection and still have in the portion that Ms. Love wants it for
So
by
really 16
redacting a smaller part of it.
I should have said 16 to 17, if I was
Okay.
to be more precise.
Okay, so any issue with just taking, with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quindarius Act. No objection.
Okay. So. So that's 66, 17 through 18. Out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was.
Yeah.
We're asking.
I don't, Mr. Short, did that have some issue?
right, 60, they're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know until you went to court yesterday. So I think that should come out 6819.
Okay, so that's, and then maybe we just aren't lined up with
Yeah.
line numbers.
Yeah, that's my.
So 68, 19 through 21, right?
I would say,
25,
because then they go to Lucci mom again.
well, 24 maybe?
Right, okay,
Okay, like, right?
yes.
So 19 through 24, out.
And then
All right, hang on, let's make sure that we've got agreement on that.
19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachery admits that it has shootings on it. You know, it's one of the guns used in one of the shootings. So even though, as it relates to the previous portion that I agreed to, and arguably even with the previous portion, the effect on Mr. Zachery, him not denying that or him not expressing surprise, but instead saying, oh, that's Moontook's gun. In this particular case, when Dennis says what he says, Mr. Zachery doesn't say, what? Oh my gosh, no. Instead, he says it has shootings on it. Yeah, it has some shootings on it.
he says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachery said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so So that would be lines.
Glenn.
So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that. All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, halfway through too.
Okay.
Through 5 really.
Was that page 69, line 2?
Yes.
Yeah, lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so Judge,
mhm,
when Detective Dennis asks who shot up Lucci's mama's house on page 69 at line 25,
mhm,
and Mr. Zachery gives them an answer,
mhm.
I would argue that all of this is information that I should be able to ask him about. And if he doesn't, if he testifies inconsistently, he should be able to come in.
And
I'm not looking at his reason for asking to come out.
yeah, what's your,
There's no indication,
how he knows?
to the extent that my client was there, as he claims, there's no indication that he was there. And there's no indication of what his source of knowledge is. I think he's just passing along rumors. And if he says, I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on. But I don't believe he's going to say that. And he needs firsthand knowledge or another exception or another hearsay exception. And I don't see it in the state just kind of saying, oh, well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in his case. And I think that the investigators, I'm not trying to criticize them, but they're just trying to gather information, not in preparation of trying the case, but just trying to get some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just got a good position, and we ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Thug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachery, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Yeah.
so that I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachery's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be to say who did it and then didn't you tell them? I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, is sitting here in the courtroom. It would be the proper pulling out of evidence of a witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make jury go away while we figure out the basis of his knowledge,
Yes.
So I don't know if we'll swing back around to that one. Okay. Let's see. I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation, regardless of as to his testimony on the stand or as to this, but yeah, it kind of let us know what that's going to be so that I can make a determination of whether it comes in that, potentially. Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then. All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30.
All right, guys. So jam-packed day. We saw a little bit of Woody. You guys are cutting up in the chat with the days. Okay. I'm going to go through some super chats and it looks like they are back at 1:30. So I'm trying to figure out if Lead and I are going to be back this afternoon. If not, then we'll be back tomorrow for Melnick and Woody. But let us finish up our super chats. You guys are cutting up. Y'all had me crying with the whole day thing. I love our community so much. Where were we? I think we were here. Shout out to Jackie with the 199. She says, you and TLA are is that a pill? My drug? What is it? What does the emoji signify? Let us know. Shout out to JT Coin Rings. Says, hello, AV chat. Hello to you, JT. Shout out to It Is What It Is with the 99 cents. Shout out to, this is German, Schmetterling. Shout out to Schmetterling with the $2 or the 2 German bucks. Love from Germany. Love right back. Shout out to, looks like more German bucks. Says Woody finna snitch. Ain't Charleston White his mentor? I did see him do a few collabs with Charleston White. So let's see. It looks like he wants to stay out of jail. That was the first thing he said when Judge Whitaker started asking him questions. Shout out to the Innocent Bystander channel with the $5. He says, I think it's time to lock him out. Those likes are abysmal today. Yeah, guys, listen. Haven't done it yet. Lee did it last night. We were live in the first 5 minutes. He locked y'all out. I mean, I like to have the chat open, but you got to cooperate with the girl and give me a like or two so I can keep it open. So Innocent Bystander is one of my mods. I think he might be right. Thank you so much, Innocent Bystander. And if anybody could drop, and if any of the mods are hanging around, if you want to drop the link to his channel, that'd be fantastic. Thanks so much, IBC. Shout out to Chris West with 199. Says Fulton County Jail was on 60 days was on 60 days twice. That's crazy. That is insane that it was on there. Yeah, that jail, I've heard stories about it. You do not want to get arrested in Atlanta and end up in that jail. Definitely not. Shout out to It Is What It Is with the 499 says, were those Pantene designer pants that Love had on yesterday? I mean, I don't know. I don't know. The pants, I can't unsee the pants. I cannot unsee the pants. Integrity, we will put together an Amazon list. You guys were asking about that book that Lee told me about. It is $300, but there's a lot of other books that are law related that y'all will like. I will put a list together. Shout out to Michelle with the $2. Says, good morning, everyone. Please hit that like button. Jackie became a member. Welcome, Jackie. Then Jackie did this. Jackie dropped a $2 super and another $2 super and another $2 super. Jackie is feeling the love. Thank you so much, Jackie. And Jackie, did you make a mistake? Were you trying to see if it went through? I always read them in our break time. So if that's what you were waiting for, my bad. I did that to Lead once when I first went to his community. I dropped a $50 super chat. I'm like, how come he's not reading it? Did it not go through? Then I sent it again and again. I was like $200 in at that point, and that's when I realized he reads them at the end. So sorry about that, Jackie. Shout out to Shalon with $20, and Shalon says, the mismanagement of this trial continues to amaze me. Also, maybe the fact that the fate of the case relies on statements from people in custody indicates that perhaps there isn't enough evidence for a RICO case. I mean, that is correct. Like, there's not enough for RICO. And the fact that we're trying to parse things together and go through all these witness statements by different people, and it all contains hearsay, that's he, she said, he said, she said, like, it's not like firsthand knowledge of people that were actually there. It is a lot of these folks giving information during plea deals, a lot of these folks giving information while they're in custody to get out of custody. So it's a lot that doesn't quite necessarily give you an ironclad RICO case. So I agree with you on that one. Thank you so much. Shout out to Cool Blur. Oh my God. Cool Blur was like one of my first subscribers. Cool Blur with the 5 says, AV, it's been a while since I caught you live. Glad to see you're still providing us with legal breakdown and commentary and having some fun too. This is like a nice little watering hole. Like we have a really good time over here. Shout out to Don with the $5 super sticker. Thank you so much, Don. Shout out to Mindy with $19.99. Thank you, Mindy. She says it's gonna be another long day. Love loves her pink. She does. She likes her bright colors. We got the King Slime nails, right? And it reminds me of like a cartoon character, like King Slime nails. Like, I'm gonna take you down and prosecute you. And then the bright colored choice of clothing. So we can start a petition, ladies, to raid this closet and revise it. We need to do an edit on that closet. Do y'all want to join me in that? That would be a lot of fun. Shout out to FFS with $4.99 says her shoes are struggling to hold her up. Her shoes is struggling to hold her up as much as she's having to make her point. Hashtag what you mean. Man, she seems lost. She does. I mean, you dropped that a lot earlier, but wow. Shout out to Yaya, who became a new member. Welcome to the community, Yaya. Oh, this always trips me up. Shout out to the Mushroom Podcast at Your Main Man Mush with $5. And Your Main Man Mush says, the fashion gods got no love for love. Bless her heart. But this poor thing just doesn't know how to dress. It almost looks like she slept in her clothes. And, it is, the fit was a little bit, you could see the effort today. The pants yesterday were just, in the words of the innocent bystander, abysmal. Like, I couldn't unsee them. And then you guys were making your jokes like the hills have eyes. If the pants don't fit, you must have quit. That one was good. Y'all are hilarious. Thank you so much, Mush. Shout out to Jay with the $2. Has called it Melnick for the win. And Woody we trust. Yeah, I mean, they've been trying to get a hold of Melnick so far. Right before we broke for lunch, the the judge said that her office has been trying to get a handle or a hold of him. Sorry. And I believe they're still going to try. Who knows? Maybe he calls back within the afternoon and he still makes it today. So there's still hope, but she did say, let's plan on tomorrow, worst case scenario. I do like that she plans these things. FFS is back with 199, says, huh? What you mean? That's the first thing Woody said as soon as he got on the stand. She's just like, I forgot what question she asked him. He said, huh? Like, that was the first thing. It was hilarious. FFS is back with 499. He says, AV, please do a poll on who thinks he's going to plead the fifth, not testify and get locked up, or will testify. Yeah, I did that poll earlier. I think you guys were in the 70s for that one. I'm going to end this one right now. Will Melnick show up for Woody today? 70% of you guys think that he still may. Okay, and the hope is not lost, but I think that Judge Whitaker wants to be reasonable with time, right? So we'll see how this afternoon shakes out. Shout out to Shay B with $5, says Woody is okay with staying in jail until the end of this trial. Love lied and said pass this trial. Kick her off the trial. I mean, that's the thing, you know, and that's what Judge Whitaker, that's the wrong she's trying to make right, is let's, number one, confirm that he has an attorney. And thank God she did that, because he got on the stand and was just like, I don't know if I have an attorney. And she's just like, what do you mean you don't know? He was just like, well, I was talking to Melnick. So do you see how in Woody's mind, he is technically unrepresented, but still thinks that he's still working with Melnick? Do you see that? So it's actually really good that she made sure that he was represented, because guess what? If she didn't do that, we'd be in the same predicament all over again. And that would just get another judge kicked off and another one put on. And it's like, oh my God, we're just going to keep going in circles and circles and circles unless someone lays the hammer down. So thank God she actually asked him. And, you know, she's taking the responsibility. She's like, forget you, DA's office. My office is going to contact Melnick and get him in here either today or tomorrow. Shout out to Michelle with the $5, says AV7, please tell me they cannot put Woody in jail until the end of the, she says Shanghai's, I think, shenanigans. Yes, they can. She just told him that. He said, so when do I got to stay? Like, I got to stay until the end of the trial, or am I going to have to stay at the end of the trial and all the other defendants? That's what Glanville told him. Do you see how Woody remembers? He's like, I'm not falling for that again, because what the state told him is that they can hold him until the end of this trial and all of the severed defendants, which is insane. How reasonable is that? So Judge Whitaker heard DA Love say that, and she was just like, okay, well, I also want to see law that proves that you can even do that. But for now, it is to the end of this trial. So between today and tomorrow, these are the issues that we need to hash out, right? FFS is back with 499, says that they pronoun used to refer to two or more people or things previously mentioned or easily identified, people in general. No weapon formed against me with the 5, says a small bag of chips. Thank you. Thank you so much. Your main man Mush is back with 5. It says, yesterday Love's back pockets looked like they were smoking weed. Today her outfit looks like it's been drinking. Oh my God, y'all hilarious. Raphael the Moore with $2 says, they did Woody's hair in jail. I'm done. Rhonda with 199. Thank you so much, sis. Miss Love's Pants has entered the chat and drops $2 and says, stop talking about me. Okay, all right, Miss Love's Pants. I mean, you might want to button up. You might want to button up or get stitched. Raphael is back with $2, who says they did Thug's hair in jail. Pantene Pro V has entered the chat. $5 says Pantene CEO here. We don't claim Love's Pantene pants. Those are knockoff designer brands. I'm so done. These trolls are hilarious, y'all. Shout out to I'm a fan with $2 says this case is a murder trial. This case as a murder trial would have been better. I totally agree. Shout out to Cynthia with 199 says for putting me on blast. Sorry, Sin. I mean, I read my comments. You got in trouble in that house. Welcome to the community, though. Shout out to Peter with the $2 says maybe they, them could be. What if he said? FSS is back with $9.99 says watching this trial makes me appreciate Mental Health Awareness Month a lot more after watching this shit show, because it's a mind bender. It's a mind bender of a mind. Oh, Mindfuck. Yeah, yes, that is correct. Shout out to Class E Beats who became a YouTube member. Thank you so much, Class E Beats. If any of my mods are hanging around, please drop the link to his channel. This brother, I just checked it out the other day. He has been a part of my community, Leeds community, for a really long time. Actually, a really cool channel. I would highly recommend this one if y'all are interested. He's been covering the case, but in shorter videos. So if you're looking for bite-sized pieces of content, check him out. And thank you so much, Class E Beats. Really, congratulations on the growth too. You're doing well. You're crushing it on YouTube. I'm super, super proud of you. Shout out to E Capone with the $4.99. He says, AV, what it do? I'm just cool, little mama. Awesome. Thank you so much, E Capone, for stopping in. Let me catch a few of these Cash Apps, guys, and then we will jump on a lunch break. I'll meet y'all back here in a little bit. Coming to the Cash Apps. First one, shout out to Dexter with the $5. He says, thanks for keeping us abreast. Thank you, Dexter. And thank you for tuning in here. I really appreciate y'all's loyalty. Beat My Mookie sent me $3. He says, I'm getting in a little late. Will Woody testify about I think she ran out of character space on the Cash Apps. He should be testifying today about everything we need to talk to him about, and we're going to square that all away. So hopefully this afternoon, if not tomorrow. Shout out to Full Drinking and Half Inking with the $20. That's for a beverage on us. Thank you guys so much. Really, really appreciate you. Shout out to Beth, sends $15, says good luck on the bar. Thank you. I'm going to need that. I will take all the luck y'all send me. Shout out to Jen with $10. Thank you so much, Jen S. Shout out to Drew Beats with the 3, says Woody said, I never wanted to testify. He did. Did y'all catch that? He just said that. He just said that on the stand. Drew Beats hits me with a 2 and says, Woody's lawyer doesn't want him to testify. It's over. That's the thing. There's going to be this clash. Melnick is going to say, Woody, don't do this. Woody's going to say, I don't want to do it. I don't recall. I don't know. Huh? All of that. We're going to see all of that. So you're going to have this clash between these guys. I just hope you guys are expecting that because I can foresee it. Shout out to Liz with the $1. She says, Woody going to choose jail if only till this. Yeah, so Liz, we going to see. And Liz, apologies yesterday on lead side. You know why I didn't read it. You know, sis. You know. All right, guys, I'm going to run. Let me grab one more here. Shout out to Chelsea with $1.99 says, how can the state force immunity on someone? That's what this judge is trying to get to the bottom of. You can't. It's given. But is there any law that shows that it must be received? And that's what Whitaker is going to make them, the prosecution team, prove to her. Because if there is no law, then technically they can't do it. So it's going to be an interesting afternoon. You guys stay locked in. Thank you so much to everybody that supported the stream and everyone that supported yesterday. You know, I did 2 streams on my side, 1 stream on lead side. We've been all over this case. But really, really appreciate y'all's loyalty and hanging out with us and doing it here. So listen, we will see you in a little bit. Stay safe out there. I'll see you in the next one. Bye. See you guys after lunch.